Good morning, friends. Namaskar, Sasriyakal, and Adab. This is my 267th video, and this is a very important video. It's a small video. I'll be talking of a rule, authentication orders, and other instrument rules in 1958. Now, what does this actually mean? This rule was made that President of India cannot do or sign every document. So this meant that it would delegate powers to subordinate officers of the department or the ministries, and they, on behalf of the President of India, will be signing documents. So this is called basically delegation of powers. Now, Director General Lands, New Delhi, is definitely one of the departments of the Ministry of Defense. Now, it's very surprisingly in the later part for the past 2, 3 years, I've been seeing they've been issuing resumption notices in these cantonments. And these notices do not comply with the authentication orders and other instrument rules 1958. Now, this notification for our Ministry of Defense dated 3rd November 1958, New Delhi. And further, this was authenticated in an RTI letter 28th August 2008 by the Director General Lands that an officer of the rank of an undersecretary or above is competent to issue resumption notices. Various other powers were given, like to file a suit of to make a lease, to amend the GLR, various orders, and even to give educational leases. Who had the powers? Who could form the arbitration committees for compensation in cases of resumptions? So all these delegation of powers are, but I'm just going to specifically talk of the resumption notice. Now, an officer of the rank of a deputy director or a director military lands and services or the present director general land, is he being given the powers through this? Has he been delegated? Where is that notification? We don't scrutinize. We don't ask for this. We don't verify. Most of don't mind it. Now, my fraternity advocates don't plead these kind of things. So, whether these officers were delegated powers under the Act of the President of India is to be found, and the guilty needs to be punished. And a criminal suit should be allowed or to be asked by the court to be filed against that signatory who has done it without the delegation of powers. So, the resident, I'm just trying to strike the nail in the coffers, and Union of India being as a party to the whole cases, read chapter 23, suit for instructions, defense state, page 701 to 741. How appeals have to be filed and counsels have to be engaged. Section 13 states filing of appeal against the lower court. Section 17 talks of delegation of powers of cases and suits where appeals have to be filed. Section page 732, it briefs that there is a general policy. The general principle to be observed is that litigation should be avoided as far as possible, and it will generally be in the interest of the government to leave parties to file a suit against us. Why? Why does the government do? Because the burden of proof will lie on the person who files the suit. This is very clearly given in the court, this chapter. Read page 735, part 2. It clearly reads that under section 16, results of suit is to be briefed by government pleader to the DO in duplicate. In paras 4, opinion of government pleader as to appeal by government with such clear instructions for filing of suits and appeal is given for the councils. Then also these responsibilities and laws are not adhered as given. No information is given to us. Why? We need to understand the ministry is totally in a denial. It is in a node and a mode that these lands are ours. Now, I have various judgments, and I remember Mr. P.N. Lekhi when we were meeting, and Mr. Srinivashan and the retired then Chief Justice, who's no more, he gave me a chronologically list of how delegation of powers can be pleaded and countered. So he made a brief. He says the administrative power is an arbitrary power, discretionary executive. Henry's eighth clause ipso dixit, judicial review, jurisdiction, right, quasi judicial powers, statutory powers, suo motu powers. So he gave a full profile. Now, under the parliament, has power under entry 97 of list 1 of 7th schedule to enact laws for grants of pension to former members of parliament. Where is it written? It's written in various, and there is a judgment on society versus common causes versus Union of India, 2002 1 SCC 88. So we can dig in as many judgments. I have a full profile of more than about 30 40 judgments on delegation of powers. So understand all those people who've been issued resumption notices in the past 2 3 years. There is a fraudulent doing going between the Director General Lands and the issuing of resumption notice. There is a performer for the resumption notice. So friends, please wake up. I know there are many people sitting in Jhansi, Jalandhar, who have become advisors. I think somebody was sharing me even in Pune cantonment. In piecemeal, we may be having the best legal luminaries around. But try and understand this is cantonments governed by special laws. These laws are not taught to us when we are doing a law. So, friends, please wake up. We are old grants, revenue free grants. We were never converted into new grants by the British. So there is no question of your and my grant being a grant under GGO 179 or either 260 or any. Why? Because then we would have been new grants. Thank you. Good day.